Right now, it's my great pleasure to welcome to the program Stephen Halbrook, who, in addition to his many other credentials, is the author of numerous books on the Second Amendment, including A Right to Bear Arms, State and Federal Bills of Rights and Constitutional Guarantees, That Every Man Be Armed, The Evolution of a Constitutional Right, The Founders' Second Amendment, Origins of the Right to Bear Arms, and his most recent book is Gun Control in the Third Reich. His work has actually been cited by the Supreme Court when the court has ruled in favor of the traditional pro-gun rights understanding of the Second Amendment. So it's my great pleasure to welcome to the program right now Stephen Halbrook. Stephen Halbrook, thanks for being here.
Thank you for having me, Tom.
Well, I just got done telling people about all your books and your expertise on this subject. I can't think of anybody I would be more interested in featuring to talk about this topic that never seems to go away. I mean, when you're an expert in this topic, I would think you don't have any shortages of speaking engagements or inquiries. But I want to talk about specifically, though, the text of the Second Amendment and what it means. Now, it seems to me that maybe over the past 20 years or so, it seems like there has been a kind of a scholarly convergence on this subject, where even people who might not, in their heart of hearts, be super interested in the right to bear arms, nevertheless have had to admit that, well, you know what, the gun rights people more or less are correct about the Second Amendment. Am I right about this?
Yes, you are. There's an interesting history about that subject, namely that when the Second Amendment was adopted, the Bill of Rights was ratified in 1791. There was never any controversy about the meaning of the words, and it combines two different thoughts. It's got the Militia Clause and then the Arms Clause, and the Militia Clause states a principle of political philosophy where regulated militia being necessary to the security of a free state, and then the arms guarantee, the right of the people to keep and bear arms shall not be infringed. That was never controversial until about the 1950s or 60s, particularly in the 1960s. And at that time, there was a big push nationwide to pass all kinds of firearms prohibitions and registration of handguns at the national level, things like that. And so the idea was invented that the people means the National Guard, and to bear arms doesn't mean to carry arms. It means only to have them in the military. One word was perverted after another, and the term right, instead of being a right of the people, it really became a right of, or a power of states to maintain militias. And then you had a number of federal courts actually adopt this nonsense. It was only in 2001, actually, the first federal appellate court, the Fifth Circuit, in a Texas case, basically held that the Second Amendment does mean what it says, and finally the Supreme Court did that in Heller in the 2008 case.
So then let's go into what exactly it does say. And I know that you take the Jeffersonian view that the Constitution and the amendments are written in a way that the average person is supposed to be able to understand it. You're not supposed to need years and years of legal training. And in fact, to the contrary, years and years of legal training seem to impair people's ability to understand the Constitution. So I think the difficulty people have is that there's a bit of a philosophical preamble to the Second Amendment. When it talks about the militia, this, for some people, colors the whole amendment, that the whole amendment, therefore, has to do with the militia. So can you separate that for us? I mean, what is the role of the militia in the Second Amendment, and why does the presence of the militia in the Second Amendment not deny that we're talking about an individual right to bear arms?
First, let me go back to one thing you said, which was right on point, that years of legal training seem to disqualify people from knowing what the Second Amendment meant. You had the ridiculous situation of back in, I think, about 1991, when the Bill of Rights bicentennial was being celebrated. There was an American Bar Association report that smugly said that more than half the American people wrongly think that the Second Amendment protects their right to possess a handgun. And so here you have these,
right.
I mean, lawyers are the only people who could say without laughing that the people doesn't mean the people. So,
I know.
So that was the original meaning, but there's no problem with having more than one thought in the amendment, just like the First Amendment covers a whole bunch of subjects. Establishment of religion, freedom of the press, freedom of speech, assembly and to petition the government for redress of grievances. The idea that there can be more than one thought in one of the amendments is pretty simple. So the Second Amendment combines only two instead of about six like the First Amendment. So you have well-regulated militia being declared to be necessary for the security of a free state, and that had to do with, we had our bad experiences with the British standing army, and there was quite an aversion to these professional armies, mercenary armies, what have you. And the idea was that the militia would be, in the first instance, the true guarantor of liberty in a free state. Everybody understood a well-regulated militia to mean the body of the people trained to arms. It didn't mean over-regulated by government. It meant that they knew how to shoot well and they could cooperate together for mutual defense. Recognizing that the people have a right, the people at large have a right to keep and bear arms, that would promote a well-regulated militia. This well-regulated militia would be impossible unless the people could keep and bear arms. Anytime you would have a military force armed by the government, it can be disarmed by the government. And their thought was that we've had enough of this omnipotent government with the British. By recognizing this right, you would have people exercising the right. They would have their own guns. They'd be ready to be called out in an emergency to overthrow tyranny, defend against invasion, defend against insurrection, all those things. So that's what the framers were thinking about. That's how they tied the two thoughts together in one amendment.
What can we figure out, based on the contemporary sources, would have been considered to be the limits on people's right to bear arms? For example, were they envisioning that everybody would have the right to have the most advanced technology of the time? Like, in other words, could everybody today have a tank and then point to the Second Amendment as justification? Was there any type of limitation envisioned in the Second Amendment?
Well, I think the text of the Second Amendment itself does that. It says, keep and bear arms. Bear arms means to carry arms, and so if you're a person carrying an arm, you're not driving a tank or having a jet fighter. So I think that's inherent in the text. Now, although at the time this was discussed, there never was any prohibition then, like of an individual possessing a cannon or anything. That was fairly common in some places, in fact, where you had independent militia companies, for example. And it wasn't until the 1968 federal gun control law things like cannons and mortars and whatnot were actually regulated. So you had a lot of veterans bringing all kinds of stuff back in World War II, but it never really led to any harm. At this point in history, these kinds of things are highly regulated, and nobody argues that there's a Second Amendment right to them. But at the founding, there was no regulation of that type.
Now, you've got quite a bit of material in this book, The Founders' Second Amendment, that starts off in the years before independence. So what kind of light is shed on this overall subject by studying that history and beginning there instead of just beginning with the drafting of the Second Amendment?
Well, you have to know what led to the Second Amendment, why it was considered a problem, the idea of the populace being disarmed, and also the antecedents of the Second Amendment. You start with the English Declaration of Rights of 1689, declared that Englishmen have a right to have arms, whether it was the term. Blackstone talked about that right as meaning basically a right to personal defense and a right to resist oppression. So it was very well ingrained in the minds of the colonists. And then that right got stepped on by the Crown, because at the same time the Crown was attempting to force the various impositions of taxation and closing Boston Harbor and seizing merchandise, things like that. In order to enforce those things, they had to send a standing army to Boston, and they had to start taking measures, put the squeeze on gun possession, and finally to try to deprive the colonists of arms. So you have things gradually happening, like a ban on importation of firearms and ammunition into the colonies. Back in those days, they had large powder houses where large amounts of gunpowder were stored, and that was black powder, which was a lot more volatile in those days. So like a gun shop wouldn't have more than a few casks of black powder, and the rest would be in the public storehouse. And so General Gage, who was head of the British forces in the Americas, made it where people couldn't get gunpowder out of these powder houses. That was called the powder alarm. Then things started happening, like militias starting to be disarmed, and you had finally, the searches and seizures of people going in and out of Boston to search for guns and then to take them away. And finally, all hell broke loose when the Brits sent troops to Lexington and Concord to take away the militia arms that were there, and they got beat. Not many people know what happened after that, though. General Gage, who was governor of Massachusetts colony as well as general of the British forces, declared that everybody in Boston had to surrender their arms if they wanted to leave town. Everybody wanted to leave town then. And so they all, on the designated day, it was a few days after Lexington and Concord, turned in their arms at Faneuil Hall, which is still there, of course. And they took your name down and what you gave them, and they were supposed to give them back. And then the British soldiers came and seized them. And that was considered an act of perfidy by General Gage. So there you had the first seizure of civilian arms of people who had nothing to do even with the resistance activities at Lexington and Concord. And so, from that point, it became a question of armed revolution. That was sparked 1775. The War of Independence went underway, and basically at that point, the rules of war applied as opposed to the normal rules of, you respect others' rights to free speech and to have arms. Well, both sides were busting up each other's presses and seizing each other's arms and things like that. But that was the impetus for the Second Amendment.